Hello again, this is Ben Hitchcock Cross talking to you today for Deliberate Indifference, Wisconsin. I'm talking about whistleblowing here and the Garcetti rule. This discussion is not intended to be legal advice because it may or may not apply to your facts. Okay, Wisconsin law applies whether you understand it or not, so consulting with an attorney is often the best way to make an informed decision. I think a lot of people, and we'll use a Debbie Keither example here, see Debbie Keither and think that they can't do that. Well, that might be true if you're employed there, but I think it's a totally different story for the people who are not employed by MPS, who were formerly employed by MPS and have a lot of secrets that they could and probably should be telling. Not just for Debbie Keither, certainly, but for the children of MPS, for their coworkers left behind, and for the citizens of Milwaukee, and certainly for the students and the children who would really benefit by some proper management here. And I think we all know what's going on. We know the board is not doing what it should be doing, and we know that there are people who have access to this vital information who are no longer with MPS or other governmental entities and who really should be sharing. Because it's too long that some of these retirees are sitting here sort of tapping Debbie Keither on the shoulder from behind the scenes and, wishing her well, waving to her from across the street, so wishing they could do more. Well, they can do more and they should do more. And here we're here to talk about why they're in a different position than those who actually work there. Okay, so this video is going to drop sort of in a series with Calvin Furman's letters, whistleblower complaint to Keith Posley and to the board about Marla Brunei. And so we're going to juxtapose, let's compare and contrast what Calvin Furman was able to do while he was employed and how he frankly could have been punished for it. And so he took a step braver than most in that sense, and he knew he was leaving, I think, and that influenced his ability to make that decision. But nevertheless, there is a line there between when you're employed and when you're not. So let's talk about Garcetti. Okay, so this is a Supreme Court case, 5-4. The conservatives won out, and it says that basically your right of free speech stops when you're employed by the government because the government is the one paying you, and so you owe them a duty of loyalty back that trumps, in all cases, your rights of free speech here. So Mr. Ceballos was an attorney district attorney working at the district attorney's office. Mr. Garcetti is the district attorney. So Mr. Ceballos gets a call from a defense attorney saying, hey, your case is full of balloon juice, and I think your sheriff's deputies are lying. So Mr. Ceballos calls up the sheriff's deputy, and he thinks they're lying too. So I think not only did he wrote up a memo, and he shared it not only with his bosses, but he shared it with the defense attorney as well. Well, I think kind of shockingly, the district attorney went through with the case. The defense attorney called Mr. Ceballos as a witness. Mr. Ceballos testified against his employer because he didn't have any choice. He was called as witness, and that he would have received protection for, but not for the making of the statements originally. And unbelievably, the judge in that case ruled in favor of the government there. And despite the fact that the former attorney on the case was saying that he believed the facts supporting it were false. But I guess that's what happened. So then, of course, retaliation follows, because that's what happens. So this is Mr. Ceballos, that they had after a heated meeting with his boss, he was moved to another position, transferred to another courthouse, and denied promotion. Retaliation. That's how they do it. So he filed in federal court because he had suffered an adverse employment action, he believed, because his First Amendment rights were violated. Well, went all the way to Supreme Court. He won one or lost one at the first level, one at the appeals court, and then at the Supreme Court he lost. And I guess we all lost in a sense. So what's the rule? The rule is if you are employed, you can be punished, meaning it's legal for the government, it's not unconstitutional for the government to adversely affect your property interest by suspending you or demoting you, terminating you, so forth, because of a statement that you make on the basis of knowledge that you acquire while you're employed. What does that mean? If you learn it on the job, you can't talk about it in public. Okay, we had this problem continuously during COVID where district employees who have just had it with things would go up at virtual meetings and tell parents what was really going on. This is not Milwaukee Public Schools. This is all over the state, all over the country. This was going on. Well, all of those teachers were exposed, and many of them did suffer disciplinary consequences based on that information. Why? Because they gained it while on the job. Okay, so if you're a teacher and you find out something in the, that you read it in the, this is Pickering. If you read it in the, you go to their minutes and you go read the budget and you find out in the budget that something fishy's going on, and then you go to the board and you make a complaint, and then they go after you. That's protected. Okay, you like to go through the garbage because you copy of the FBI and you're junior G-man, right? And you go through their garbage and you find out, secrets about the sports coaches, something. Okay, you find scandal. You go and report that scandal. That's protected. Okay, so that's the line. Information that you acquire publicly, you can do what you want with all day. You've got free speech rights all day long. What you don't have is information that you acquired while on the job. Okay, now, what can they do to you? This is the key thing to keep in mind. They can't send the goon squad to your house and beat you up. They can't arrest you. They can only discipline you, okay? Well, what does discipline apply to? It doesn't apply to parents. It doesn't apply to former employees. And it doesn't apply to people who are employees that never were employees, okay? So it only applies to current employees, meaning people who they have the power of employment power over. Okay, so that's what you need to keep in mind. That's what that law is. That's what the rule actually is that you can be punished while you're employed by a government for disclosing information that you learned on the job that they don't want you to disclose. Okay, so those people who know facts about the government, particularly MPS, particularly malfeasance at the superintendent's office or the board or things like that, firsthand, that have experienced and are recently, especially those who are recently retired, almost have no excuse but to start making public statements here. So this is my call to you. This is my explanation to you, and I guess I need to disclaim before we end here that I discussed Wisconsin law with you, and okay, but here we are, and you know what the rule is and what you can say. So before you have to understand, I guess the best way I can put it to you is this: they can't do anything to you if you're not employed there. Okay, so if you've got something to say, you should say it. Thank you, and have a great day.